My name is Jonathan Melmed. I'm an employment lawyer in California, and I represent employees across the state. It's really important for lawyers to maintain integrity when speaking to clients, when speaking to judges, and when speaking to opposing counsel. There's always a very fine line when negotiating on behalf of a client in trying to get the best result for the client, but also in remaining honest, fair, and accountable in what you say. And so it's really important that when I speak to judges, when I speak to clients, when I speak to opposing lawyers, I always know that I'm saying things which are backed by evidence. The most simple way to maintain accountability is to make sure that whatever I'm saying, that I know I have strong evidence for, I have documents, I have witnesses, and I know what I'm gonna say, exactly how I'm gonna say it, and exactly what evidence, specific evidence I'm gonna use to back up exactly what I say. When clients come to our firm, often they're expecting a specific outcome. And that's really important to remember during the very first call with the client, all the way through the very end of the litigation, the end of the case. And so for our firm, we always measure success by looking at whether or not those goals were actually achieved. Did the client get what they wanted? If you're an employee in California who's looking to hire a lawyer because of a dispute, because of some sort of illegal activity in the workplace, maybe because of harassment, discrimination, or an illegal termination, and you've got a claim, you've got a case, you've got an issue, or you've got some kind of dispute, you're going to have a goal. There's something that you're gonna want to happen at the end. And the way to think about that is you're gonna have a reason for wanting to call a lawyer. Why did you call a lawyer in the first place? Why are you now watching this video? Why are you now seeking to find a California labor and employment lawyer? And whatever that reason is, that's your goal. And so when we decide whether or not a client's case was a success in our firm, we look at the initial reason. Why did the client want to hire a lawyer? What was that goal? And did we reach that goal? All of the staff on our team, they're all focused on one thing, representing California's workers. And those representations, those cases that we do, they all have one goal and one particular result that we're always looking for, which is getting the best result possible for our clients. We represent plaintiffs or individuals, workers. We stand up for workers who have been victims of harassment, discrimination, wrongful termination, unpaid wages, maybe even sexual harassment in the workplace. We stand up for people who are employees, who are California's workers. And you know, when you're hiring our law firm, every single lawyer at our firm is dedicated to exclusively representing workers in California and other states. If you're looking to hire a labor and employment firm, it's really important that you speak to the lawyer directly that you want to represent you. Oftentimes, people will call a law firm and they won't actually speak to a lawyer. They may speak to a staff member, a paralegal, or a legal assistant. Now, those people may be very competent professionals, but if you're not speaking directly to a lawyer and you're not hearing upfront on day one what the strategy is for your case, then you've got a lot of questions to ask. How is the lawyer going to prosecute their case? What are the steps the lawyer is going to take to make sure that your goals are met? What are your goals and how are they going to be met? I think that it's very important for a client who's talking to a law firm to not only tell their story, but also to be interviewing the lawyer, almost like a job interview. Why is this lawyer the right lawyer for me? Does this lawyer understand the issues that I'm dealing with? Has this lawyer dealt with those issues before? Has this lawyer been successful or unsuccessful in those issues and in this area? You may find a lawyer who only practices law or labor and employment cases in Southern California, but you're in Sacramento or San Francisco, or maybe even as north as Humboldt County. The other option is you may find a lawyer in Northern California, but you're in San Diego. So you really want to find a lawyer who's not only got the experience that you're looking for in the practice area, but has a robust practice across the state that can represent you wherever you are in California. One of the differentiating factors of our law firm is that we focus a tremendous amount of resources on new technology in order to more efficiently represent clients. That means two things. One, we want to know that we can represent clients in a better way. We want to use technology that's available. We're always trying to see what else is out there, what softwares are out there, what we can use to better represent our clients. But two, not only do we want to know that we can represent clients in a better way, but we want to know that we can represent clients in a faster, more efficient way. We want to know that we are using the best technology to get you the best results as quickly as possible. When you walk into a lawyer's office, you may find a lawyer who's got a bunch of cardboard boxes and files strewn all over the floor with loose papers everywhere and completely disorganized. The alternative is to walk into a lawyer's office with streamlined, efficient, technological operations. So it's up to you what kind of law firm you want to hire. At our firm, we are always at the cutting edge. We are always looking to find out what are the newest ways, what are the freshest ways, what technology is out there, how can we better represent our clients. So when you come to our office, you're going to see that for the most part, we're paperless, we're organized. Our team is focused on efficiency, on technological innovation, and making sure that we always have the most up-to-date software and case management systems in order to organize your case and to get the best result for our clients. When you hire our law firm, we don't expect you to pay a single dollar up front. You don't have to write a check. You don't have to pull out your wallet. You don't have to pull out your Apple Pay. When you hire our law firm, you take nothing out of your pocket. And if we don't settle or win your case or recover on your behalf, you owe us nothing. The way our law firm works is that when you're ready to hire a lawyer and you come to us and you've chosen our law firm to represent you, we don't charge anything. Our attorneys are only paid if and when we recover on your behalf. The way that the structure works is that you only end up paying a reasonable portion of the recovery from your case. And if there's no recovery, you don't owe anything and you don't have to pay anything. You don't have to pay costs up front, you don't have to pay attorney's fees up front, and there's nothing you need to pay if we are unable to successfully recover on your behalf. When our law firm decides to take a case to accept a client, it's really important that we know that the case is one where we're able to recover on behalf of the client. That way, we know we've got the evidence, we've got the testimony, we've got the witnesses, the documents that we need to properly prepare your case. So when we take on a case, we know we put in the sufficient investigation to know that your case is one where we're going to be able to actually be effective. And that's really important for you to know. If you speak to our lawyers and we're not able to represent you, it doesn't mean that you don't have a case. It doesn't mean that what happened to you is not true or that we don't believe you or anything like that. All it means is that we don't think we are in the best position to represent you in connection with what you're looking for. And if that's the case, that's okay. There are many other lawyers who you can speak to, and we're happy to refer you to other lawyers who actually may be better and be more equipped to represent you in connection with your case. When we take on a case, we bear all of the financial risk. We cover the costs of mediations, we cover the cost of depositions, we cover the cost of postage, we cover the cost of court filing fees. We don't charge any money up front. There is nothing you need to pay up front, and we take on the full financial burden of your case. And that's because when we take on a case, we believe in it. When you tell us your story and when you've got the evidence to prove your claims, we believe you. And we want to take your case and we want to help you. And we do that and we put our money where our mouth is. We front the costs ourselves, we front the fees ourselves, we don't ask you for a dollar, and we only ask that we are paid at the very end of the case if and when we can recover for you. And if we don't recover anything for you, you owe us nothing. I'm going to tell you about one of the setbacks or failures that I've experienced in the practice and how it's impacted my practice of law and how it's impacted how I represent clients moving forward. It's very easy for lawyers to sit and talk to you about all the times they've won, all the big cases they've settled, all of the growth that they've experienced, but it's much more challenging for a lawyer to tell you. It's much more vulnerable for a lawyer to share with you an experience where they've experienced a loss. A few years ago, our law firm brought a case on behalf of an individual where we were almost certainly confident that we were going to win that case in front of the judge. And when we prepared the papers, when we prepared the evidence, we conducted the depositions, and we were certain that the judge was going to take our side in the case. Unfortunately, the judge did not take our side, and we had to give our client sad news that we were not able to recover in the trial court. And we decided we were going to appeal the case. And bringing an appeal is a very serious consideration. It costs a lot of money, it takes a lot of time, and the client needs to be very focused and sure that that's something that they want to do. And when we brought the appeal, again, we were certain that we were going to win. We didn't. And we ended up getting a result that was not favorable, and a result that we did not agree with, and a result that did not align with our client's goals. And it was a very difficult and humbling experience. I'm glad to report that has only happened to us one time. However, when it happened, it was a detrimental blow to me personally and to our law firm. But I used that experience to move forward to give better representation to future clients. That experience allowed me to share with clients risks and pitfalls in a potential case. It allowed me to predict how certain judges would rule on certain issues. It allowed me to be able to share my story with other lawyers that represent employees in California and share with them some of my experiences and how what happened to me they should be on the lookout for so that it would not happen to them. So while that was a pitfall or a failure or something that I'm not necessarily proud of, it was an event that was impactful and something that I'm going to carry with me for a long time moving forward, and it will allow me to better represent all of my clients as I move forward with this practice. One of the most difficult and challenging parts of being a labor and employment lawyer in California is hearing the stories of our clients who have gone through tremendous amounts of distress before contacting us. Usually, when an individual contacts our law firm, it's because something bad has happened to them. And oftentimes, the thing that happened to them that was bad is very distressing. It can be emotionally disturbing, it can cause loss of sleep, anxiety, stress, all sorts of negative consequences. And so for us, when we hear the news stories of potential clients who need help and representation, it's very difficult and challenging for us. However, one of the best outcomes that we can get, or one of the most rewarding experiences for us, is when a client comes to us with a distressing event or with something that happened to them that was illegal, where we know that we can get them a result to solve their problem. And oftentimes when we explain to the client our plan and our strategy, we aren't 100% sure whether or not we have the evidence to prove the claim. We aren't sure whether or not we have the witnesses in line to prove the claim. And we don't necessarily know what is going to be the outcome. But we can coach, we can provide guidance, we can provide counsel. And the most successful moments for me in being a labor and employment lawyer is when our coaching, our guidance, our counsel allows the client to actually reach their objective and to solve their problems and to reach their goals. And those are the most proud moments for me. When a client follows the trajectory from coming in distressed, upset, angry, anxious, going through the litigation process, which can be grueling, which can be difficult, which can be time consuming, it can be lengthy. And when the client's objectives are met, when the goals are met, when the results are achieved, that's a success for me.